Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about declarations by cities and provinces. Cases that should have gone to the Supreme Court of Canada, but didn't. Everybody's familiar with provinces or cities that declare a day to be a day in celebration of something, or a week to be a week in celebration of something, or a month to be a month in celebration or in memory of something. And in Ontario, the Ontario government enacted legislation declaring a particular week of the year to be Tamil Genocide Awareness Week. And for the purposes of that week, the legislation that was passed encouraged people to reflect on the Tamil genocide that had occurred and to educate themselves about it. It did not require people to reflect on it. It did not require people to educate themselves on it. It simply declared the week, a week in memory of this, and encouraged people to learn more about the history of the world. And an individual as well as a Sri Lankan association both challenged the constitutionality of this legislation, arguing, number one, that it was outside the scope of the province's authorities to make a declaration about a week in honor of something that happened outside the borders of Canada, because provinces only have jurisdiction to create laws over things that concern things within their province. And secondly, that the law infringed on the individual's Section 2B rights of free speech and their Section 15 rights to not be subjected to discrimination. And the Supreme Court of Canada declined to hear the constitutional challenge after it was dismissed in the lower courts. But the case does raise a very important issue. And obviously, there's nothing wrong with legislatures wanting to declare weeks in honor of certain things. But where we have legislatures that take vastly different views from the federal government on certain international issues, especially at this point in history, it is important to rein in the power of provinces to effectively declare things that might be inconsistent with federal objectives as they pertain to international relations. Think, for example, if the province of Alberta were to declare Donald Trump Appreciation Month. The federal government probably wouldn't like that, considering the US government is making threats about invading Canada and imposing tariffs. And so the inconsistency between what a provincial government may seek to achieve and what a federal government's ends are as far as international relations is exactly why these constitutional protections take place. And the Supreme Court of Canada could have recognized that despite the fact that oftentimes these declarations are very performative, and oftentimes these declarations produce no specific legal effects, there is still a possibility that they may. And stopping something like that from happening before it does is important to ensure that international relations are not compromised by hasty or poorly thought out decisions by provincial legislatures that may be inconsistent with the broader values of Canadian society. This may not be one example of that, but that does not mean that there won't be examples in the future. And the Supreme Court of Canada could have gotten ahead of this issue and could have stopped it in its tracks. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bolt Creative for putting together these videos. Please like, subscribe, and share with your friends.